Hi, this is Todd Kelting. This is the Tuesdays with Todd video edition. We are putting the pieces together. Today we're talking about the risk of a retaliatory eviction and how to avoid that. In Maryland, and specifically in various jurisdictions in Maryland, you're prevented as a landlord from retaliating against your tenants. That's a concept that makes sense. And what it means in the real world is that if a tenant complains to you or to the county or to the court about the condition of their apartment, if they are forming a tenant association, if they're doing any of the listed, itemized things that are jurisdiction specific in some cases, protected activities, if after the tenant engages in a protected activity, you give them a notice to vacate and you can't really demonstrate that the notice you gave them was for something else, there's a real risk that the notice you're giving will appear to be retaliatory. And it makes sense. If a tenant breaches the lease on February 1st and on February 15th, the tenant complains to you about the condition of their apartment, and then on February 16th, you issue a notice to vacate based on the conduct that happened on February 1st, a judge or a jury is going to ask why you waited 15 days and why you didn't issue the notice on February 2nd or February 3rd, why you waited until after the tenant engaged in some sort of protected activity to issue your notice. It's important then to remember that if a tenant breaches the lease, there's no reason to wait. Take action, issue a notice. That way, the notice that you issue can't be retaliatory. If you wait for whatever reason until after the tenant engages in some protected act, then the notice you're giving will be viewed as retaliatory. You can rebut the presumption that the notice you gave was retaliatory, but why have an uphill climb? Why not issue the notice as soon as the breach occurs? Even if the tenant is not breaching the lease in a way that would warrant a 30-day notice or a 14-day notice based on the breach, if you know 2 months into a tenancy, 2 weeks into a tenancy, 2 days into a tenancy, that the tenant is a tenant that you're not going to redeem after the 12-month lease has expired or the 2-year lease or however long the lease is, if you know that the tenant is eating up your time, is a problem tenant, is harassing your other tenants, even if they're not breaching the lease, as soon as you know that you're not going to renew the tenancy, you should think about issuing the notice to vacate at that time, even if it's for a lease that expires 12 months later, because as soon as you issue that notice, you avoid the potential for retaliation after the fact. If you know on February 15th that you're going to give the tenant a notice to vacate at the end of the lease, even if the lease expires in October, if something the tenant does in March or April or May or June is protected, let's say they file a rent escrow case or they complain to the county that there is a problem with their heat or their air conditioning. If you've waited to issue the notice for whatever reason, the fact that the tenant has made that complaint in the meantime before you issue the notice will make your notice appear to be retaliatory. So the message I hope I'm making clear while I'm ignoring the puzzle in front of me is as soon as you know you want the tenant to go, take action, don't wait. That's Tuesdays with Todd and putting the puzzle pieces together.